student loans, and preparing for trial. This video covers discovery, requests for documents, depositions, interrogatories, witnesses, joint statements, what to do if you are not given enough time to prepare for trial, how to submit evidence, disclosure of documents. Discovery. Discovery is a pretrial procedure where each party can obtain evidence from the other party by means of interrogatories, requests of documents, and depositions. Discovery can last anywhere from a few months to a year. If the evidence comes in and discovery is close, even if the evidence came in 6 months before trial and the other side has a copy of the evidence 6 months before trial, the judge might not allow you to submit the evidence for trial. If the evidence comes after discovery is over or closed, you have to write a motion as to keep discovery open until the evidence can be filed and presented to the other side lawyer. Do not take the chance the judge will allow you to submit the evidence. Always write a motion asking to keep discovery open or to reopen discovery. Please see Video 4, Motions, Memorandum, Certificate of Service, and Affidavit on how to create a motion and the procedure. Requests for documents. Then you probably will not be asking the other side for any documents. However, they will ask for your documents and for you to sign releases for your medical records. They will ask you to provide copies of your bank statements and pay stubs for the past 5 years. They will ask you for information regarding the jobs you worked and applied for over the past 10 years. However, you want to provide all the jobs you applied for and interviewed for since you left college, even if the job applied for is over 20 years old. All the jobs you applied for, with the dates you applied for the jobs, and the job title, and the job descriptions. It is very important that you sit down and think about all the jobs you have applied to and interviewed for, and the dates they took place. What they cannot request is anything regarding the strategy you will use in court. Any questions related to your strategy, do not answer. I will repeat, any questions related to your strategy, do not answer. They are not the judge, and they do not decide your case. They are the other side that is trying to stop you. Any question you answer regarding your strategy will give them time to come up with a counter-argument. Strategy questions are related to the following. How will you use this evidence? How will your argument be? What evidence will you be presenting at trial? If they keep pushing, just say you don't know at the time. In addition, do not trust the records they sent you. The U.S. Department of Education does not keep very good records. The records they send you regarding your student loans may not be accurate or correct. Your student loan services company will have the correct and accurate information regarding your student loans. Therefore, you need to write and get the information about your student loans directly from the student loan servicers company. Do not depend on the student loan servicers company's website for this information, because the website does not have correct and accurate information regarding your student loans. You need to write your student loan servicers company so they can look it up directly. When you write them, ask the following questions. Is the outstanding principal the interest on the original principal? Is this assumption correct? For some people who have had student loans for over 20 years, your outstanding principal will be bigger than your original principal. This is because the outstanding principal is the accumulated interest. You want the court to know that the interest on your loans is greater than the principal. This could help, because if the judge sees that the interest you pay each year is so high to where you will never be able to pay off your student loans, it might go a long way in getting the loans discharged. When you receive the letter from your student loan servicers company, the letter is not the only evidence, but also the envelope the letter is in. The envelope helps to prove that the letter came from the student loan servicers company and that you did not create the letter on your computer. Remember, do not trust the other side's lawyers, and do not trust the judges. This includes the lawyer from the U.S. Department of Justice and the lawyer for the Educational Credit Management Corporation. Depositions. A deposition is where you will go to the other side's lawyer's office and answer questions under oath in front of a court reporter. It can last for 1 to 2 hours. Anything you say at the depositions can be used against you at a trial. Many will not have a deposition, and for the ones that do, it usually means the other side's lawyer is trying to find something to use against you at trial. Do not trust the other side's lawyer. They will use every trick in the book. This includes the lawyers for the U.S. Department of Justice and the lawyers for the United States Attorney General. They can only ask you questions on the evidence you have reviewed. If you have not fully reviewed your medical records or any other evidence, then state that you have not reviewed it. Interrogatories. Interrogatories are a set of questions sent to you from the other side's lawyer for you to answer. It can be used against you at trial, so be careful on how you answer the questions. Do not answer any questions related to what evidence you will present at trial, or any question that asks what you will do to prove your case. Answer all the questions regarding what evidence you have, but not how you will use the evidence. These kinds of questions are trick questions, designed to get you to give up your strategy. If they know your strategy before trial, then they can better prepare a counter strategy against you. Answer these questions by saying that you do not know at the time. Witnesses. If you have a witness, create a notice which tells them the date, time, and place of the trial. Then file this notice and mail the other side a copy. You are only creating a notice and the certificate of service. Your notice only has to say the following. This example is on our website. Now comes Jane Doe, debitor, plaintiff, give notice to Dr. John Smith to appear and testify on April 13th, 2016 in courtroom 3504 of Judge Dave Trout, located at the U.S. Bankruptcy Court, 600 Grant Street, Pittsburgh, Pennsylvania, 15219-2702 at 2 p.m. on August 23rd, 2016. You can also create a summons. How to create a summons is in Video 8. Student loans and bankruptcy. How to start the process. Joint statement. A joint statement is very, very important. The court will require you and the other side to write a statement on the facts you both agree with. Be very careful with what you agree with in this statement, because you cannot change it later. The smallest detail can make all the difference. And what is also important is what's not said. For example, you have student loans of $100,000. This is true, but what is left out is the fact that you took out these loans over 20 years ago, and the fact that the original principal was only $40,000, and now the accumulated interest is $60,000, which makes your loans now $100,000. If the information about the interest is left out, the judge will not consider that the yearly interest has gotten so high that you will never be able to pay off your loans, or that your interest is higher than the loan. Because the interest is higher than the original principal, the judge might not discharge the loans, but she might discharge the interest of the loans. Very important. Make sure that the information on the joint statement has on it what the original principal is, and what the capitalized interest is. You need this information. You need the court to know that the outstanding principal is different than the original principal, and how the outstanding principal is calculated. Do not trust the U.S. Department of Education for this information, and do not trust the other side's lawyer. Write your loan servicer company and get this information directly from them. If you have a disability or a medical condition, make sure the joint statement states that you have this condition, such as a learning disability. If the other side says no, then ask why they said no. If they disagree with anything you would like to put in the joint statement, ask them why. Whatever facts they told you would not be included in the joint statement is what you must address in your brief and at the trial. If they say that the diagnosis is too old, or some other reason, now you know that you must submit articles to help counter this argument. Court cases and appeals have been won and lost on joint statements. Be very careful what you agree with in this statement. Not enough time to prepare for trial. One trick judges use is not giving you enough time to prepare for trial. Before you have a trial, you will have a pre-trial conference or evidentiary hearing. At this conference or hearing, the judge might say that she has been fully briefed, so there is no reason to write a brief. This is a trick the judge is using to kill your case. What you might have to do is write a motion asking to reopen discovery, or write a motion asking for more time to prepare for trial. You can tell the judge that there is information that was not in any of your motions or other briefs that you think is important to your case. You can tell the judge that because of your disability, or because there are facts that you and the other side did not agree with, facts that you thought no one could disagree with, you need more time to prepare for trial. You need to write a brief addressing these issues. A brief is very important because it allows you to provide testimony and evidence you might not be able to provide at trial. Remember that some judges will not write a ruling on the issue. This means that you never ask for more time or to reopen discovery. If the judge says no and does not provide a written ruling on the issue, then write a motion. Everything that is done in court, you want a written document of it. Without a written document showing that it was presented to the judge, you have no grounds for an appeal. This will kill your case. How to submit evidence. Disclosure of documents. Before you can submit any evidence that can be used at a trial, you must follow the procedure and use the federal rules of evidence. First, you must file the evidence with the bankruptcy clerk office and provide the other side with a copy. The following example of the disclosure of documents is on the website. Please look at the following example. This example is on our website. The title is Disclosure of Documents. The next line is very important, which states that you will present the following evidence at trial. This is important because you are giving the other side notice of what you will be using at trial. File all of your evidence as soon as you can, so that the other side cannot say that they did not have enough time to review your evidence. If the other side does not have 3 months to review your evidence, then the judge might not allow you to use your evidence at trial. Look at the next line. It states, pursuant to the federal rules of evidence Rule 401, Rule 803.3, Rule 803.4, Rule 902.6, and 902.10, I am submitting the following evidence. This tells the other side the laws that allow you to submit the evidence. The next line, you are listing all the evidence that is attached to this document. Next, sign, date, create the certificate of service, and attach all your evidence. Evidence. The evidence you will need is not limited to the following. Every case is different, so some will need more and others will need less. Pay stubs for the past 2 years, medical records or medical evaluations or medical assessments, divorce papers, repair estimates, rent contracts or mortgage payments, bank records for the past 3 years, tax returns or tax transcripts for the past 2 years. You can get a free copy of your transcripts from the IRS. Your yearly earnings. You can get a free copy from Social Security of your lifetime earnings. Jobs. All the jobs you applied for, with the dates you applied for the job title, and the job description. It is very important that you sit down and think about all the jobs you have applied to and interviewed for and the dates they took place. This means all the jobs since you left college, even if it was over 20 years ago. Some judges will say that the jobs were beyond your ability. You did not apply to enough jobs. Judges use this as a method to kill your case. Showing all the jobs over the past 20 years will help you counter this method and may help you win an appeal. Newspapers, periodicals, and internet website articles. If you have a learning disability, you want to attain as many articles or information as you can that prove that a learning disability is something you are born with. If it is not diagnosed early in life, can affect you negatively in the future. Many judges believe that a learning disability is not a real disability. Please review the video 9, Learning Disabilities and Other Medical Conditions and Disabilities, and Tricks They Use to Kill Your Case. There is a lot of useful information that applies to everyone. Student loan amount. You will also need to show the court your student loan's amount, including the interest and the monthly payment amounts. Write your student loans holder's company or the U.S. Department of Education for this information. Very important. Make sure that the information has on it what the original principal is. and what the capitalized interest is. You need this information. You need the court to know that the outstanding principal is different than the original principal and how the outstanding principal is calculated. You need the court to know that the outstanding principal is the capitalized interest on the original principal. If the interest is greater than the original principal, it can play a big factor in your favor in the court's decision. Do not depend on the other side to provide this information to the court. The other side will leave out the fact that the outstanding principal is different than the original principal and how the outstanding principal is calculated. Anything that can or might help you win. Plus, just because you file these documents with the court means nothing if you do not verbally state them in your trial. Remember, you have to verbally state these documents during the trial or they mean nothing. We will review what to do at trial in video 12, the trial and pre-trial.